And they have a small presentation that we just got to IT, so.
Commissioner Gardner, I see you. Can you hear us?
Yes, I can. Can you guys hear me?
Yes. Okay.
All right, we should be good then.
Go ahead and get started. We welcome everyone to today's commission meeting, November 29, 2023. And we have, I'm here, Commissioner Sakovich, Commissioner Gardner's remote. Commissioner Brandon Gordon is unable to connect, and so he is not here, but we'll go ahead and begin the meeting with just the two of us, and we'll suspend the rules to allow that. As we do for all county commission meetings, we'd like to invite the public to participate and help us with an opening of a reading, prayer, or thought, followed by a pledge of allegiance by another person. Is there anyone here that would like to do one or the other?
I can do the pledge.
Pledge. Thanks, Ezra. Anyone here could lead us in a prayer? And with that, Ben Stanley, would you be able to lead us in a prayer?
I'd be happy to.
Thank you. Then we'll invite you to come up then.
All right. Our Father in heaven, we're grateful for this chance that we have to assemble together as a government by the people and for the people and of the people. We express our gratitude for the blessings that Thou hast given us and for this month of Thanksgiving and the chance that we have to celebrate all that we have been blessed with. We pray that Thy Spirit will attend us in this meeting today, that we'll be able to have civil discourse and conversations about budgets and other matters of importance to the public and the citizenry of Utah County in a way that will bring us closer together and help us to understand each other's perspectives. We're grateful for the good men and women who serve in this county and for all the people who do so much to make our lives easier. And we pray that Thy blessings will be upon those who make such sacrifices. And we ask for Thy blessing, express our gratitude for Thy tender care, and do so in the name of our Savior, Jesus Christ. Amen.
Amen. Thank you. Thank you, Ben.
Please stand and join me for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, thank you for that. We have no other items except to go through the regular agenda to see if there's any items we would like to hold for discussion, and those that we don't need to discuss, to put them on the consent. So items 1 through a whopping number of 7. Are there any items you would like to hold, Commissioner Gardner?
Item number 4 is the only item I have to hold, and then I think we can strike 8, 9, 10, and 11.
Okay. And I can concur with that. Number 3 is so stated. So we will we'll move to regular agenda, all those items, consent items. And we have no other business, so we can go right into agenda number 4. All right, we had a couple questions on these items, and I should just confirm with our clerk before I jump ahead any further. Alice, would you confirm what we just directed on this?
You bet. I have us holding regular agenda items number 4, and then as far as closed meetings, we're going to strike 8, 9, 10, and 11.
Good. So we have just the one agenda. Okay. Then we'll go ahead and agenda number 4.
All right, Commissioners, Adam Beck, Utah County Attorney's Office. I know that there are several applicants who are here, so I know that they would like to speak on their item, but we can just go in the order that you would prefer.
Let's go ahead and I like to, at least for my part, look at number. These used to have a sequential number assigned to it, but in the third column, we use those numbers, 0024. I'd like to go ahead and discuss that one briefly. 002.
Would you mind saying the name on it as well? Because I have mine organized by name. So when you
Okay.
give the parcel number, can you at least
Okay,
give the
then-
name as well? That would help me.
Then Michael Barrow is the first one. Kathy Farah is the second one that I'd like to cover.
Okay.
The Mansion House is the third one for me. Taylor Anders, Water's
I've got
Edge.
that one as well. Hmm.
And then lastly for me, Gillies. Do you have any others, Commissioner?
Did you mention Jonathan Hunsaker Garrison?
We did.
That was the only other one that all the ones I had you
I-
mentioned except for
I
that
did not
one.
mention
I don't think
that,
you
no.
mentioned
So
Okay.
we'll hold Gunson, Hunsaker as one of that. Okay.
that. Okay. Yeah, it looks like most of ours overlap. So
Yes. Okay. Great. Then, for me on Michael Barrow, could we touch on that briefly?
Yes. So owner purchased this property in 2022. Due to a notary error that they were not informed of, the title was never transferred to their name. They ended up having to pay taxes on it as if it were a secondary residence. This property is their primary residence. And in this situation, we didn't see a county error here. The notice of discrepancy was mailed to him in July 8th. New owner was added to the property ownership per the document. Anyway, it seems like the issue here is between the owner and the title company, not a county thing. And so that's why our recommendation was to deny.
Deny it. So this is a error on the recording side only, not the county, but the recorder. When they bought the property, it was a notary error.
so the title company you're saying?
Yes.
Correct.
When it's a independent party, not the owner, I tend to lean toward the favoring the owner of the property who's making the claim. Your thoughts, Commissioner Gardner?
What was the amount?
That was $1,299.
And was that the difference because this was taxed as a secondary residence instead of a primary residence?
Yes. It says that they ended up having to pay taxes on it as if it were a secondary residence. This property is their primary residence. They're requesting the difference between the escrow estimate and what was actually paid, which is the $1,200, almost $1,300. And the change happened
Are they there?
I'm here. Can you hear me?
No, you're there. I'm wondering if
Oh.
the applicant is present.
I panicked here. I thought we lost connection.
Sorry. No, I should have clarified.
I don't see a representative for this item.
Okay.
So if they if the address was recorded incorrectly, how did they find out, or how did they find out about even owing their taxes?
Note here says due to a notary error that there was not informed of, the title was never transferred to their name. Hence, they having paid taxes on it as if it were a secondary residence. They're conferring off to the side now.
So the notices had been sent to the previous owners as of July and October of 2022. We didn't get the change until August, and so that's when he got his first notice.
So the change happened in August. He got his first notice in, excuse me, let me back up. He got his first notice in
October
October
of this year.
So just a month ago.
Mm-hmm.
I'm leaning toward approving the owner's request in this.
Yeah, and it looks like they haven't paid the full amount, so we actually won't be refunding anything. We'll just be not charging him the difference between primary and secondary residential. Is that correct?
That looks right, yes.
Okay,
Yeah, I'm okay with that.
so we can note this change. Okay. We'll go to the next item, which is the 0023, or the Kathy Farah. This individual is deceased. Do we have anyone representing the estate? The comment here is that the owner passed away and her children are having a hard time taking care of her estate. They're requesting the interest be abated, which is about $237. And humanitarian, we normally want the property owners here, but this is a little bit different. So on humanitarian side, I'm willing to approve this request. Commissioner Gardner, do you have any thoughts on this one?
So you're just looking at approving the penalties, right? The interest and penalties due to
Yes,
the death in the family.
yes. It's
Okay,
like,
I can concur with that.
okay. So we'll concur with this one. And then yours, the Jonathan Hunsaker Garrison item, Commissioner Gardner?
I only if that person is present do we need to review it. I just thought that was one that they may want to come and speak to us.
Is anyone here for that?
Otherwise, I'll go with the recommendation.
Anyone here for that property? No one is. And no one online, I take it, Alice? No? Okay, it's just us then, okay.
Okay, then I'm fine with accepting the recommendation on that one.
We'll keep that one. Okay, the next one then would be the mansion house. There are 6 properties in this one. It says the owner claims they never received the primary residential exemption forms for their 7 parcels due to an incorrect mailing address. The owner claims that these parcels qualify for the primary residency exemption for both the years 2022 and 2023 because they are rented to tenants on long-term leases. Notes here say the primary residence exemptions changed in 2022 and was forwarded, notifying the owner when this goes to the commission meeting. I'm not clear on that note, but maybe you could clarify what this comment is about.
Oh, yeah. We have spoken with the owners about this in the past, and they wanted to be present. Mr. Drew Riley is here to speak on it from from that applicant.
Okay.
I'll just give you a little info here. From the county, we have the same mailing address on file since 2017. It's on the owner to update us of any change of address. And the assessor's office recommended to deny for the 2022 and 2023, but approve on the 2024. And I do want to change my recommendation here for the 2024, but my recommendation still stays the same for 2022 and 2023. So I just wanted to update that recommendation, but also give Mr. Riley an opportunity to share.
Okay. Mr. Riley, please. When you come up, introduce yourself.
Drew Riley. The situation on these, I believe I own 20 properties in Utah County, and this address, they did get mailed to a previous rental. It's the only property I have that's not paid through escrow. The taxes need to get manually paid. It's been long-term rented, I believe, since I bought it for 5 years. And the interesting part about, I guess, this situation is, and I think there's a lot of people that are confused like me. I didn't claim any of my other properties with the form that got sent. I didn't claim these ones because I didn't get them. But on my other 18 properties, I didn't respond back either, and none of my tax got changed. And I think the reason I was confused was because in Heber City, where I own a piece of property, and in Washington County, their response to me was, hey, is this home a primary home or a secondary home? Or I didn't know about the vacation rental thing. So the form that I received from my other properties said, is this house a primary residence? No, it's not. It's a rental residence. My primary residence is the house that I live in. In Washington County, where I do have a second home, they asked, is this a primary residence or is this a second home? I said, this is a second home, and I was taxed differently there. Sounds like in this instance, they wanted to know if these 7 units were being rented on Airbnb. But the form I received was asking, is this residence occupied as a primary, I believe, more than 50%? Which it's not. It's not my primary residence. It's not my secondary residence. So me as a property owner owning multiple properties, none of my other taxes got bumped. And I didn't respond to any of those forms as well. These 7 units did. I'm not quite sure why. Maybe it's because they're in a business name or whatnot. So I'd like to comply. I'm pleading ignorance here. I mean, I didn't do it on any other ones. It's just these 7 units got bumped, and it's just for those 2 years. I called to ask to change the election. They said I couldn't change it, and I'm requesting if I could look at getting it changed, getting the past 2 years corrected. That's why I'm here.
We have the county assessor here. Maybe he could speak to this as well.
I'm Bert Garfield, County Assessor. As far as getting out the letters, we make our best attempt to get a letter to every property that appears to be non-owner occupied. But to clarify maybe a confusion, it's a state law that any property that's rented to a long-term renter does get the primary residential exemption. So your properties in Wasatch County and Washington County, if you have a long-term renter in there, they should be getting the primary residential exemption. It's not just, so that's a statewide thing. So just to help you with that. So anyway, I'm not know if I can help so much with why some of its properties got some letters and some did not. But all the information's online so that everybody can go online at any time and see what their tax statements are. So it's available all the time. So hope that helps.
Anything else? Yes, please.
Well, yeah, I mean, is there any answer on why, I mean, how do we decide, right? I mean, I can pull up the county tax records and I mean, my name is listed on, like I said, 11 properties. Well, how do they decide? How do they know? I obviously don't live in all 11 of them. So why didn't 10 of those get bumped? You know, so is there an answer on why these 7 did and why my other 11 didn't? And also tax rates did get bumped. So when I look at it and I'm saying, okay, some of my tax values did get bumped because the values got bumped. And so I'm looking at this saying, oh, my values got bumped $900. Maybe the value went up, which they have. That makes sense to me. I didn't know that it's because my tax rate changed because we're deciding to tax them as long as the vacation rentals. But just to clarify, there is 3 tax elections, right? There's primary residence, there's secondary, and then there's vacation.
No, I think
Is that
it's just the
correct?
two,
It's just
the
primary and two?
primary
Okay, got it.
and
Sorry.
the secondary, yes.
Sorry, that was the other counties. There's 3. So
It's the same statewide. So when you say other counties, it's not, it's for every county, there's only 2.
okay, got it. So I mean, that's all the information I have. Is like,
Okay.
thank
Okay.
you.
Can we have council come back up and review what your thoughts are based on this information?
When we called in,
So they have updated it.
yes.
Yeah, you know, there is that question that he has about why some of them got bumped and some didn't. You know, we can just speak to what we show, and we have the same address that we've been using since 2017.
Okay. I'm looking toward, there's been no claim of administrative error on our part. There's no claim of administrative error on the owner's part. Commissioner Gardner, do you have any additional insights on this?
No, just that, I mean, if the notice was sent asking if this is being used as a primary residence, then we did our due diligence by sending and asking, is this used as a primary residence? And that doesn't necessarily mean by the owner, that means by somebody, by anybody. And so for the future, I agree. If we now know that these are being used as primary residences, moving forward for the future, they should be taxed as that. But for the past, if we mailed the form and it was not filled out and that address hasn't been changed, and that's the address we've had on file since 2017, and then there was no administrative error. And so the past taxes, they kind of are what they are.
I will say he confirmed that they have since changed the address, but not in the years previously.
Then my thought is,
But they were still getting the tax notices.
say that again, it broke up just a little bit.
But he was still getting those tax notices, and he would have gotten the notice that we needed to know if this was a primary residential use or a secondary use,
Okay.
right?
Yes. Okay.
Yeah, I mean, he would say that the notices were going to a tenant, not to him, not to where the other ones went. But we were sending it to the same place that we've been sending it since 2017.
And I'm comfortable to make a motion to deny this request.
Yeah.
And again, I just wanted to make it clear that I did make a change to my recommendation to allow the primary exemption for 2024.
For 2024 only.
Yeah, and I would agree with that. Yeah, for 2024 only moving forward.
Okay.
Not even for 23. Can we talk about 23?
And so I would go with the recommendation.
So your recommendation is not with 23?
Correct. For 2024.
Does the 2024 request need to come before the commissioners right now, or can it be handled administratively?
We called to change. They asked us to go and get 4 pieces of identification from our tenants. I don't even manage the tenants, you know, and I can show you 5 years of leases, right? But it's like the request for the information is also ridiculous, asking for driver's license and bills and car insurance, and by the time we called in to make the request.
Well, the reason I ask is because this board can only adjust taxes that are due and owing, and 2024 taxes aren't due yet. So this board can't really approve the primary exemption for 2024. If that makes sense. That's not why we're here today. We're only here today to ask about reducing tax amounts owed. And so 2024 really needs to follow whatever administrative procedure exists. And then that's how 2024 should roll out, unless anybody here sees.
No, like I said, we owe the 23s, which I know we missed the deadline, I know we didn't appeal, I know we didn't fill out the form, but part of the issue too is they wouldn't even. Sure. I know we missed the appeal, I know we missed the form, but this started because to change the election for 24, we were having a very hard time to do that. So we started this whole process. And so we owe the 23s. And, once again, it's not rented. It's never been vacation rented. I can show you 5 years of leases. I know procedurally the forms were sent. I know that. But the point is yes, 2 years, we've overpaid, we've double paid. So if you want to get us on this one, fine, get us. And it's crazy that you did send, we can check the records. I'd like to now pull every single form that they sent me on my other properties, which they did. I received those forms, and I didn't fill them out, and I didn't send them back, and my tax rate didn't change. Some of them, they actually went down. And so I don't know why I got taken on these 7 and not the other ones, but I don't feel like that's fair. And so I do owe the 23, and I have paid the 22. I overpaid it. And so if you're willing to at least look on 23, I think that's a good consideration to take, considering that if we really want to be honest, then I should owe you more on the other ones. If we're going to be honest here, if you're saying you sent the forms and everything's correct, well, then why am I not paying more on the ones I didn't fill out? What the heck?
Now, on your, perhaps Bert can clarify, but do we need driver's license? Do we just need the contract for 2020 to get the residential? I know we looked at this recently. I looked at it with Katrina.
So there's a little bit of debate about this issue at the moment. So there's a form that the state requires, and the state requires only a lease. But some counties have changed that form and added more things, like a copy of the utilities and all those other things. My predecessor changed the form so that it asked for more stuff than just the lease.
Right, okay.
However, there is some thought that maybe we can't ask for all that other information, but that's still being legally
Researched.
Okay.
Well-
Some counties only require a lease, so.
Yeah, okay. Well, that needs to be worked through, but my main point here is that the commissioners really shouldn't be addressing 2024 issues right now under this agenda item. Do you agree with that, Adam? I mean, that's.
Yeah, I agree with what Mr. Jones has said.
So can we back up a little bit then? If we're discussing only 2022 and 2023, your recommendations are?
The county's recommendation is to deny.
To deny.
Mm-hmm.
Okay. I'm good with that recommendation. Okay.
Thanks.
Go on to the next property.
The next one that I had was Taylor Anders, and I'm wondering if Taylor is there or a representative.
Is there anyone online?
Commissioners, this is Paul Jones. I'm actually working this request, and I have a little follow-up work to do. So if it's okay, can we continue that item for 2 weeks?
Continue item
Yep, that sounds great.
for
Thank
2
you.
weeks.
Yep, continue Taylor Anders for 2 weeks. Sounds good to me. Okay, the next one I had was the
Yep.
Water's Edge HOA.
Yes, commissioners. with this one, there is a representative here from Water's Edge HOA. I will just give a little background information. Well, I will say this. In talking with the assessor's office, we show that the Water's Edge Homeowner Association is the owner on file. It was transferred from Flagship Development. It's my understanding that Vineyard City intends to take it at some point, but currently they are not the owner of the parcel. And so as a county, if it's not an exempt, if the owner of the property is not exempt, then our position is that then the taxes need to be paid on it. And in speaking with the assessor's office, there's nothing on the recorded plat that indicates the parcel is a common area. And you'll be able to see those recommendations there. But because of this, my recommendation was to deny the request. But I did want to give.
Is there anybody from Vineyard City there?
I think we do.
So,
There's someone that previously was with Vineyard.
yeah, I actually had been speaking with Ezra a
Okay,
little
if
bit.
not, if no one from, I was going to say, if no one from Vineyard City is there, I'm going to call on Ezra because I have
Okay,
a couple of
yes,
specific
I
questions
did speak with
that he would know
Ezra,
the answers to.
and then Ezra is no longer working there. And so I did reach out to the new individual, but I have not heard back from him. I imagine there might be some complications, coming on board with a new job, so.
Because this is so this is a complicated item, I wonder if we shouldn't continue this item.
Well,
I just have two questions for Ezra, and then I don't think we need to continue it if Ezra wants to come answer my question.
Sure. Happy to answer any questions.
Does the city of Vineyard maintain this property?
Yes.
Like, the city of Vineyard cuts the grass, maintains it?
Yes. We actually had an event, or
Is it
the city of Vineyard
listed-
actually had an event there yesterday or Monday this week, and it's operated as a city park.
Is it, so the maintenance is done, is access to it restricted, or is it open public access as per Vineyard Parks?
Yes, it's open. It's listed on our website as a city park. Anybody in the community would just recognize it as a city park. They did have some issues recording it over because those taxes were charged, and that's the only reason why the city doesn't own it, to my understanding from researching it.
Okay, so the city has it listed on their website as a public park. It is common space, and the city maintains it.
That's correct.
Yeah, I move that we abate the taxes so that the city can then actually take possession of it, since they have been acting as the owners and it's been public space.
I'm happy to do that.
Okay.
Let's go ahead. Although it'd be more fun to wrestle legally on this one. Okay. We have then, I think, a final item.
Commissioner,
Never mind, we got a comment yet?
Yeah, may I ask for some clarification? We represent Water's Edge. There's two parcels at issue. And the clarification that I'm seeking is, in our view, it should be abated back to 2020, which is the time when the plat was prepared
Oh, yes. Yeah.
and approved by Vineyard. Prior to that, it should not be abated because it was just developer ground that wasn't ready to be conveyed and dedicated to the city. But in 2020, and I have evidence in the form of a plat that was approved by Vineyard, from that point forward, it should be abated. With that resolved, we're allowed to record the deed to Vineyard as well as the plat that's already been approved. We've got a
Yes.
stamped Mylar. So with that clarification, I have no other comments.
Yes. Do we have the tie a specific
Yeah.
date to that transfer?
It would just be for tax years 2020
Okay.
moving forward.
We'll just consider the whole year. Okay.
Yeah, thank
We'll
you.
make that part of the motion then
Thank you.
for 20. 20.
Are we clear on which parcels we're talking about? I'm just seeing one parcel listed here.
Do you want me to address that specifically? Water's Edge, page 22. Well, I can, in fact, I've shared a little slide deck, and maybe that's helpful to put this on the record to get absolute clarity. Would that be okay, Wade, if I walk through this? Okay, this is from the interactive parcel map. It depicts Penny Springs Park. As you can see, it's split diagonally down the middle into two parcels, one ending in 4-6 and one ending in 4-5. There were really two developers here. One was Woodside. That's who deeded the park area to the association, unbeknownst to the association and without the association's acceptance. But the critical years are 2023, which has not been paid. 2022 was paid. 2021 was not paid with respect to parcel 4-6. 2020 was also paid as well. But with respect to the other parcel, it's 2023 and 2022 that were not paid. 2021 and 2020 were paid. But the plat, so this is the CC&Rs depicting that area as a public park. So that was always the intent. That dates back to 2020. Here's the approved plat that we have been unable to record because of the delinquent taxes that dates back to 2020 as well, showing the parcel to be dedicated to Vineyard City. So 2020 is the operative date, but these are accurate listings as to the years where taxes were paid and the years where taxes have not yet been paid. So we're looking for an abatement or refund back to 2020. And then that will allow us to clean this up and have it be a public park as it was always intended to be and how it's been used since its inception and creation.
I got that.
What was the date? What was the date on that plat?
On the plat? So if you look at the plat.
The reason I ask is
Yeah.
because 2020 could be a partial year,
That's
right?
That's true. However, if you go to the CC&Rs in 2020, which are of record, it was identified as a public park. Now, I know the argument was made, and I'm a little perplexed by staff's recommendation on this based on the discussions we've had, but they said the plat does not identify it as common area. However, under the Community Association Act, a plat and a set of CC&Rs are to be read together on similar hierarchy as any of the other governing documents. So when we have any ambiguity or missing information on a plat, we look to the recorded declaration of covenants, conditions, and restrictions, which are done concurrently on a new development, and this clearly identifies it as a public park. So I think we can go all the way back to the beginning of 2020 to identify this. I mean, and just from a matter of equity, there's been a big ribbon cutting. It's never been treated as a private parcel for any kind of pecuniary gain. There's been no profit from it. It was dedicated for the public good, and it doesn't make sense to tax people for property that was given up for the public use and benefit.
Tyler, is this, you threw up multiple parcels, but on the application itself, you only had one parcel.
So if you look at this plat right here, do you see how it's to be recorded? It does not show that diagonal subdivision.
Uh-huh.
If you go to how the county has it currently designated, it's split down the middle. Both parcels are affected identically. It's the same issue pertaining to both parcels. So to the extent the application should be amended or expanded to address this, we certainly can do another application if it's necessary. But the issue can all be dealt with here with one motion and decision by the commission.
It would be my position that because this application was created for the 0046, that to touch on the other item, we'd need to have an application for it. Yeah, that would be my position.
Is that something we could address on a future consent agenda by expanding it to encompass both?
I'm going to say we should be able to do that, because we have done similar motions like this in the past, as Commissioner Gardner's indicating now.
So I would say we can approve this one, but then for the other recorded property number, the plot number, you're going to have to put in another application, and we can handle it the same way.
We'll do that. That's totally fine. We'll get that prepared. and submitted.
And then we just need to underscore that we need to harass Vineyard for not actually possessing their own properties.
Yeah, so the way that came about is very unique. I mean, Woodside Homes was getting a tax bill. They didn't want to pay the bill, so they deeded and recorded it without the knowledge of the association, which offloaded the responsibility from them. It was only after really diving in that we figured out what happened. It's different than any other kind of property transfer where you have a title company and willing parties. It was just recorded unbeknownst to us and transferred without our knowledge. So absolutely, Vineyard has already
But
approved.
it also means that Vineyard was budgeting for and maintaining a park
Yeah,
that they didn't own the property of.
that's true and has still been doing
I would
that.
harass their city manager, but I hired him, so I can't.
Well, thank you for your time today and understanding on this. We'll get an application on the other parcel so that we can have it be done properly. Thank you.
Sounds good. Thank you.
Hi, Andrea Allen, County Recorder. I just want to make sure that the record is straight, that the recorded subdivision plat, that is the actual physical record, not the map that showed the name of a park. The actual recorded plat does not indicate that that is anything other than a lot. I'm good with what you're looking toward doing, but what was shown as Penny Lane Park is not on the official record. When they get to the point that they record the new amended plat that vacates that and creates a park, then it will be on the official county record.
Thank you.
Thank you for that clarification, Andrea. Just make sure that we get that done as we record that.
For 2020, this is Paul Jones. I'd recommend that the commission only take action to regards to 5/6 of that year because the plat was recorded at the end of February, so that leaves 10 months out of 2 months it was privately owned in 2020. But
Speaking on behalf of the association, that's acceptable to us. That seems like a fair and equitable allocation of 2020.
Legal happy?
Sounds good.
Good.
Sorry, one last thing. Additionally, there has been some taxes paid in the past. Do you want to abate all delinquent taxes as well as refund any that have been paid?
For my part, yes, that would be part of the whole package.
Yes.
Yes.
Everything except for 1/6, apparently,
Yes.
of 2020.
For
1/6 of
2020,
2020.
right.
Yeah.
Are we finished with this one?
I believe so. Adam, we good?
Great. Thank you. Then on the next property, the Bonner Giles.
All right, commissioners, this item has come before you previously, back in August. This parcel had been assessed as a buildable lot. And he had a rollback, and when this last came before you, we changed the property was assessed as buildable, but it should have been a non-buildable lot. And so we changed the value on going back 4 years. Our position is that a statute does not require us to go back any further than 4 years, and so that's still our recommendation, is that we don't need to go back further than 4 years. There is that fifth year that did not get changed. I did want to provide a little update. This item had been on appeal at the State Tax Commission about the Greenbelt issue. The decision came down in favor of Mr. Gillis. My recommendation is we are in the appeal window for the assessor's office to determine whether they want to go further and have a formal hearing or not. In a couple weeks, when we will know whether the assessor's office is going to appeal or not. If they do not appeal, then this matter may be a moot point, and because we will probably have to figure out a way to reinstate the green belt. But if they do appeal, then this matter is ongoing, and so my recommendation is not to abate the full green belt rollback because there is the potential of an ongoing appeal.
First off, we got to quit meeting like this. The other day out here, a guy asked me, he says, how much service time you got here? I says, oh, I don't work here. He says, well, I see you here all the time. What are you doing? I says, well, I'm over here discussing some issues with my farm. And he says, well, no wonder. There's not a farmer in the bunch there. You got to stop out at IFA on the way out of town. Hey, that's the way I kind of feel on this. But here's what I've got. Nearly a year. In January, I received the letter in the Greenbelt. I tried to talk Diane. It took a little bit of problem talking to her. In February, we met with the commission and the board, and we tabled the meeting because we wanted to discuss it further for another month in March. But it came about in March, and you put me back in the Greenbelt. About this time, I found out that this piece of parcel property was erroneously registered as a building lot, valued at $159,000, with a tax of $1,600 a year when it's out of the Greenbelt. I went through the process with Springville City, not qualified for building lot, and got it reassessed to $17,168 year taxes. I revisited the county several times, clearing this up. On April 14th, I filled out the owner's statement of circumstances and request for relief, the letter. Do you have that letter there? I guess you do.
You know what? I don't have it with me.
Well, I can tell you, that letter, in that letter, do you want me to read the letter?
Please.
The property in question is currently in Greenbelt rollback appeal, documents included. In reviewing the property status at the assessor's office, the property was incorrectly classified as a building lot, which makes the market value much greater than it should be. The property is a long, narrow strip, 240 feet long by 41 feet wide, 24/100 of an acre, which does not conform to any type of building lot in Springville. It is currently being used as pasture and produce for animal feed. It is a good green space, but not zoned for much other. Springville attorney documents, I got no change in plans for the property use. I am asking for the property value to be readjusted and the corresponding rollback years of delinquency also to be reviewed and adjusted. Okay, thanks for your time and consideration. I got a letter. Well, I came over and we met here. And your conclusion and what I concluded out of it was that it was abated. I gave you the letter, Tom, the other day. Mm-hmm. And anyway, that it was all abated. Well, let's see, on April 14th, I fill out the statement of circumstances and of relief. I attended 3 commissioners' chamber meetings in July that tabled the owner's statement. You were too busy and it was tabled, but I came over and it was tabled. And finally, on June 26th, I received your decision, the letter, and that's the letter that you've got. And that was my understanding that it was all abated. When I come over to pay just before I came over to pay my taxes, I get the original bill. It was $5,800 in taxes. And I said, hey, you must not have got the information. And I talked to Treasury and everybody else. In fact, I couldn't even pay my house taxes that day because it was all tied up. But in the meantime, I've paid my house taxes. I paid Greenbelt, out of the Greenbelt taxes on everything right now for this year. And I just want to get it straightened out and done with.
Yeah, no doubt. Can we have any insight from you?
So again, as I explained earlier, in our last hearing on this matter, we didn't hold the item and discuss it. You went with staff recommendation, and staff's recommendation was to abate about 4,100. Essentially, it was changing the rollback amount on 4 years from a buildable to non-buildable, and we did not include the furthest year. I believe it was 2018. So in that meeting, you went with the staff recommendation, and the staff recommendation was not to abate all of it, but a portion of it, as I've previously described. So the letter he did get, I can see, it could be a little misleading. There's what he wanted, and our recommendation was not that. It was an amount less. And so that's why there's a little confusion here. So that I just wanted to clarify that.
I'm curious, why was the amount less? And it sounded like we had an agreement going.
Yeah, so Mr. Gillis wanted us to abate the whole rollback. And our recommendation was not to abate the whole rollback, but to change it from a buildable to non-buildable on 4 of the 5 years. And so that's where that 4,100 or so dollars came from. And that was the decision of the commission back in August. So that's the full amount. I couldn't tell you off the top of my head, but it was around $6,500 or so.
Okay.
Well, like cowboys, county attorneys have their own words. We have a hard time distinguishing what it means too, But I'm looking at this right here too. They came out with a figure of $1,538, which had tax interest on it, of which Bert told me there wouldn't be any. And I look at this and I think, hey, it was assessed wrong in the first place. If I looked at the $168 I paid this year, if you went back 5 years on that $168, it's only $840. So why am I assessed $1,500 and something? I didn't assess it. That's what it was.
We've got this, we have this miscommunication here somehow, and I'm not sure how to unravel this one. But he sees one thing, and we tried to express what we see, and evidently that bridge hasn't been crossed yet.
This has been such a big headache for me. I mean, I put it to bed and woke up with it. I mean, it's one of them things, if you're responsible and want to pay your debts, a year sitting with this thing, I mean, it's not life or death, but it bothers me. And I'll tell you, I want to get it taken care of and out of here. I don't want to think about it tomorrow. And here's the big thing. I got the notice that I'm back in the Greenbelt. Okay, that's another entitled issue, but I don't want to be over here discussing that. Truth be known, I'd rather wipe these things out, wipe out 23 because it says I'm back in the Greenbelt, and I'll pay the taxes next year and go out of the Greenbelt as much as I've fought it. I want to be done with this.
Okay.
And just to clarify, when he says he's back in the Greenbelt, he's referring to, being successful at the initial hearing at the State Tax Commission. So, like I said before, is probably a couple weeks before the assessor's office will need to file an appeal on that if they want to continue to appeal.
Yeah, I would rather not continue the appeal, but that's the assessor's decision on that one. I would rather just go ahead and wrap this up because we've got the decision from the state. I'd rather go with that, but Commissioner Gardner, do you have additional insights on this?
So we abated 4 of the 5 years of rollback, right? And what we're looking at is abating the 5th year. I'm just asking for clarification.
If the commission felt like that was in the best interest of the state and county, then you could abate the 5th year. Our recommendation is that we don't have to. That the statute's in place that means we don't need to do that. You could abate the 5th year if you would like.
In the best human interest, right, Paul?
Best human interest, yes.
So, once the appeal was filed at the state, basically everything was put on hold until the state made a decision. The 5th year additional taxes is about $600 to $700. Between the difference of it being a buildable lot, a non-buildable lot for that 1 year. So the amount, it seems like it's being requested, is not just the abatement or not just the difference between being a buildable lot. It's just abating all the tax, all the rollback completely. So that 5th year, I'm just trying to illustrate, was only about $700.
Yeah. Okay, so if we just abated the 5th year between buildable and non-buildable, it's like $700, $800. But if the difference would be if we wanted to abate the entire rollback tax, if we feel that it shouldn't have been out of Greenbelt.
Exactly.
And to clarify, there was recently a hearing from the State Tax Commission that sided with Mr. Gillies putting him back in Greenbelt.
Now, there's 2 different forms of a state hearing. There's an initial hearing and then there's a formal hearing. It was in an initial hearing. It wasn't in a formal hearing.
Okay.
But it is true, they sided with Mr. Gillies.
Well,
but we've discussed this at length, like Bonner knows.
We have, yes.
And we can't seem to get anywhere. I have no interest in extending out this any longer than we have to. And so whatever you want to do, I'm not going to argue with it.
Okay, so here's what I'm going to do. At the risk of ruining my wonderful relationship with Mr. Gillies because he won't get to come see me anymore, I'm going to make a motion to just abate the entire amount going off of the preliminary initial hearing from the state.
And I can support that motion. Okay.
But that means that you won't get to come see us anymore because you'll have no reason to because we will have abated everything.
We'll ask him to bring a birthday cake each year after this.
Can I just say one more thing about this whole deal?
No.
Huh?
No.
Okay.
Go ahead.
Good question. Should I try to stay in the green belt after this punishment? Really? It seems foolish. What have I really won? The right to do this again next year? New penalties, sign away my privacy with Google Earth, drones, whatever else they can send through my backyard. You have to sign that over. That almost sounds unconstitutional, that you have to sign to let that kind of stuff happen. What happened to the deal of coming to the ranch and talking to the guy and looking and seeing what you got and talking about it? Okay. You'll know more about the ranch than I do. A little vengeance from those about me going to state with this, and mostly the deterioration of my health and mostly the deterioration of my 82-year-old body. Where's John Wayne, the Lone Ranger, and the crew from Gunsmoke and Brigham Young when you need them? I was born in the right time and place and thankful to have grown up under the hand of the greatest generation and the fabulous 50s. Things have changed, and it now looks like rural America has lost its innocence, and it started at the bottom with those who feed you, the farmers. One large question: What are we telling our young future farmers? I say, please don't kill small legal acreage too fast. It may come back to haunt you. Letting small acreage go to the building lots, making more reasonable housing with more irrigation water for the Great Salt Lake and more tax revenue does come with a cost. Less green space and farmers. I've seen the best of it. Now with this new approach, my thoughts are we're going to see the worst of it if I live long enough. Again, these are my opinions and do not take them as an insult personally by anybody. One other thing. To you, the county commissioners, thanks for your patience. You've been kind, considerate, and professional in all your judgment. I'd vote to you anytime, everywhere. Thank you.
Mr. Gillies, I want to say on the 8th day, God made the farmer, and I appreciate you being the farmer that God made on the 8th day.
Thank you.
All right. We've gone through the list that we pulled out. Was there anyone here for any of the other properties that we had not talked or touched on it thus far? Seeing none. Okay.
I'll make a motion to approve item number 4 with the previously stated amendments and notions.
And I can second that. All in favor, say aye.
Aye.
Aye. That passes 2-0. And we have no close items. You've got some time for public comment. Seeing none. Final motion.
Motion to adjourn.
We are adjourned. Thank you, everyone.